We are live. We are live. We're ready to start whenever y'all are ready.
I'm ready.
Are petitioners ready?
Yes, Your Honor. Stefan Guerrero, Speaker 1, Team 7 for the petitioner.
Thank you.
Your Honors, may we reserve 2 minutes for rebuttal?
Yes, you may.
Madam Chief Justice, Your Honors, and may it please the Court. My name is Stefan Guerrero, and along with my colleague Mario Sanchez, we represent the petitioner, the Department of Homeland Security, in this matter. I will address the first issue of whether the Department of Homeland Security's rescission of the Deferred Action for Childhood Arrivals, or DACA program, was arbitrary and capricious under the Administrative Procedure Act because it rests on the legal premise that DACA is unlawful. Mr. Sanchez will address the second issue relating to the Equal Protection Clause. The department's rescission is not arbitrary and capricious because DACA at its inception was unlawful, and because the department has examined the relevant data and provided a satisfactory justification for the rescission. DACA is unlawful for 2 reasons. 1, because Congress has already spoken to the precise question at issue. And 2, because the department's creation of DACA was not a permissible action in construction of Congress's delegation of authority. Returning to my first point, as this court told us in Chevron, if Congress has already spoken to the precise question at issue, then that is the end of our inquiry. The courts and administrative agency must give effect to the unambiguously expressed intent of Congress. Now, Congress has already spoken on this precise question at issue because it has already granted deferred action through statute on 3 occasions prior to the creation of DACA. First, in 2000, Congress granted deferred action to self-petitioners under the Violence Against Women Act. Then in 2001, Congress granted deferred action to family members of lawful permanent residents killed by terrorism through the USA Patriot Act. And finally, in 2004, Congress granted deferred action to relatives of non-citizens killed in combat who were posthumously granted citizenship through the National Defense Authorization Act.
Counsel, hasn't Congress repeatedly declined to enact DACA?
Your Honor, Congress has repeatedly declined to enact similar legislation to DACA, specifically the DREAM Act. And it is this rejection which shows that Congress had considered granting benefits to DACA recipients and actually said no. And as mentioned before, in the previous instances in which Congress decided which classes of persons would be eligible for this benefit, in clear and detailed language, Congress makes no mention of granting the benefit to individuals who were brought to this country as children.
I have a different question, though.
Go ahead.
Judge Countess, go ahead.
No, it's okay. You started.
I have a different question. Is Congress's refusal to explicitly act the same as answering it unequivocally? For example, they didn't exclude somebody from a class in legislation that passed. So how have they precisely addressed this issue and rejected it by refusing to act more globally?
Your Honor is correct in that Congress has not explicitly excluded this class of individuals from the previous instances of this congressional legislative deferred action. But when we look at their previous enactments in combination with their consideration and rejection of the DREAM Act, which was directed toward DACA recipients and would have provided similar relief, those two considerations of Congress are what create the unambiguously expressed intent of Congress.
But did they reject the DREAM Act? I mean, that didn't fail a vote, correct? It passed one house and no action was taken in the other. Is that rejecting it?
It is a position of petitioners that is rejecting the DREAM Act, Your Honor. While it was, brought up on vote, in the end, it was not able to get passed either by the other house or committee. It just stopped there, and so that is what we contend as a rejection of this.
Mr. Guerrero, I'm sorry, Judge Countess, you go ahead.
We might have the same question. I just was going to ask a while back. I'm not sure I agree with you that the DREAM Act and DACA share the similarity that you might be putting forth. So why don't you enlighten me? What similarity do you see that you're relying on? Because in my view, the DREAM Act provides a legal path to citizenship that DACA was never going to provide. And isn't that the key element?
Yes, Your Honor, you are correct in that the DREAM Act and DACA both provide different forms of relief, but they are specifically targeting toward the same population. So in Congress's consideration of the DREAM Act, we know that Congress was looking at DACA recipients and deciding what form of relief they should be allowed. And yes, Congress did intend, or Congress was considering, going one step further and providing a legal path to citizenship or permanent residency. And in rejecting that, or in rejecting, a lower step of relief, such as statutory deferred action, Congress has spoken directly on this question. Does that
I
answer
guess-
your question, Your Honor?
It does, thank you.
My question is related. What is your best authority that we must defer to Congress, or that the executive branch must defer to Congress, as opposed to occupying that space jointly?
Your Honor, again, the authority is what this court stated in the Chevron case. When Congress has spoken directly to the precise question at issue, then that is the end of the inquiry, and Congress and the administrative agency must give effect to that intent from Congress.
I feel like on this side, though, that we're all wondering if they've spoken directly to it. They haven't addressed or enacted legislation, and you're equating a failure to take an affirmative action as addressing it explicitly. And I'm struggling about whether those really line up.
Okay, Your Honor. As this court stated in Barnhart, we typically cannot read a negative inference from previous enactments of Congress. So like the three examples in which Congress has granted deferred action through legislation, you typically cannot read the negative inference unless it is fair to assume that Congress considered the unnamed possibilities and meant to say no. So what Congress's consideration and rejection of the DREAM Act does is it shows us that Congress was considering, the unnamed possibility of granting benefits and relief to DACA recipients. And in considering and rejecting that, we know that Congress intended to exclude this class of individuals from the statutory deferred action that Congress could have imposed instead of lawful permanent residency.
So basically, if that is the basis of your premise, are you saying that anytime the Senate rejects a bill that Congress has unequivocally spoken with respect to Chevron?
Not always, Your Honor, but in this case, we see that Congress repeatedly, revisits this issue of granting deferred action by statute in 2000, 2001, 2004. So we know that Congress, does this often. And in considering the DREAM Act, that in combination with the frequency of how often Congress speaks to this issue shows us that in this case, Congress has unequivocally spoken on this issue.
Are you equating gridlock with action, though? It feels like inertia. Things at rest tend to stay at rest. They couldn't get it through, and you're equating that to a positive or an affirmative action.
Your Honor, what I'm contending is that Congress's failure to pass this is what allows us to make that negative inference from Congress's previous actions, because it shows that Congress has considered this and said no, whether that be because of gridlock or other grounds. In the end, the result is the same. The legislation was not enacted by Congress. Now to my second point. The next step in the analysis under Chevron is to determine whether the agency's action and construction of the statute is a permissible one. The department's action and construction of the statute is not permissible because 1, it is beyond the scope of authority that Congress could have reasonably delegated to the department. And 2, there is no specific statutory basis for the department's authority to create DACA. First, under Title VI, Title VI, Section 202, subsection 5, the agency secretary is charged by Congress.
Oh, that's fine.
I'm sorry, Your Honor?
Your time is concluded.
May I briefly conclude?
No, but thank you for asking.
Thank you, Your Honor.
Petitioner 2?
Madam Chief Justice, and may it please the court. My name is Mario Sanchez, and as my co-counsel mentioned, I will be addressing the issue related to the Equal Protection Clause. The Equal Protection Clause requires that all similarly situated individuals be treated equally. The focus of this case is whether the government's decision to rescind DACA was motivated by a discriminatory purpose or a response to an unlawful enactment of executive authority. The government's decision to rescind DACA was not racially motivated, nor was it unusual. You'll find no
It's
evidence.
unusual though, because if the disparate impact is 93% and we marry that with President Trump's language and consider the totality of the circumstances, isn't that enough to show that it's possibly an equal protection violation, if taken collectively?
Your Honor, respectfully, we disagree. In the Arlington Heights case, a mere presence of disparate impact does not mean that the—
No, but that's why I ask it in the collective. If we take the 93% disparate impact, his explicit language, the proximity and time, about how temporal it was, if we combine all of those factors together, not just disparate impact standing alone, why isn't that enough for an equal protection violation?
Your Honor, it is our contention that the totality of the circumstances were in response to DAPA legislation, my apologies, the DAPA legal challenges that occurred in the Texas case. In that case, there was concerns of legal challenges, and the Attorney General, and along with the Secretary of Homeland Security, made decisions to rescind DACA because it was similarly situated to DAPA. Under the Arlington Heights test, you will consider first whether the policy creates a disparate impact, second, the sequence of events leading to the decision, or third, the relevant administrative history. No discriminatory intent can be found for the following three reasons. First, any impact on a specific community was part of a broad decision made by the decision makers. Second, the decision makers, Secretary Duke and Secretary Nielsen, never showed history of racial animus. Third, DACA's rescission logically followed after the similarly situated DAPA policy was enjoined and subsequently affirmed by an equally divided Supreme Court. Respondent has not—
Mr. Sanchez, explain a little more. How are DAPA and DACA as similar as you seem to be putting forth? Because I don't know that I agree.
Your Honor, DAPA was implemented to assist immigrants that were parents to children of undocumented children. Similarly, DACA was implemented to help children of undocumented aliens. Both of these programs offered deferred prosecution as well as benefits to both of them.
So you're saying the similarity is just the fact that they both offered some sort of an amnesty or a deferred action?
It is also our contention, Your Honor, that the council, my apologies. It is also our contention that they were implemented through executive authority that was not done properly through statutory authority, as well as it was not done through the legislator.
But isn't it executive authority that we're supposed to be relying on now in regard to repealing or to canceling DACA? Your
Honor, I'd be more than glad to supplement a supplementary brief in the future on that specific issue, if you'd prefer. As this court stated in Feeney, respondent must prove the decision makers took action because of, and not merely in spite of, the adverse effects upon an identifiable group. Respondent alleges the rescission had a disproportionate impact on Latinos and those of Mexican descent. However, the claim forgets the broad impact immigration decisions have. Those decisions have an impact on people from many ethnicities and do not affect a single group solely. Although 93% of DACA recipients are Latinos and those of Mexican heritage, the natural immigration patterns are likely to account for that. The disparate impact on Latino DACA recipients is not motivated by any racial animus, but instead an effect of immigration patterns that have risen. As this court reasoned in Arlington Heights, The mere presence of a disparate impact does not mean the Equal Protection Clause has been violated. Finally, if we consider this broad decision to be specifically targeted towards specific groups, the government will be severely limited in their ability to adequately implement changes. Respondent also alleges that statements made by
Mr. Sanchez, are you saying that we just ignore the comments made by President Trump where he referred to people of Hispanic origin being rapists and druggists, and we're going to lock down the borders to keep them out? Is that something that is just irrelevant in this analysis?
Your Honor, as this court stated in the Arce case, in that case, a superintendent made specific statements on legislation that prohibited Mexican American studies. In this specific instance, President Trump has not made any specific statements towards DACA, nor has he made any specific input. He is not the ultimate decision maker. That ultimate decision was with Secretary Duke, as well as Secretary Kelly and Secretary Nielsen.
I'm going to
Don't they
pause
all
you.
ultimately report to President Trump?
Your Honor, although we respectfully disagree. Although President Trump is the ultimate decision maker, the secretaries set an agenda, if I may. The secretaries had an agenda set by President Trump where prosecutorial discretion would be limited. However, those decisions did not rescind DACA, nor did they rescind DAPA in the first place. The only time that these programs were rescinded was after the legal challenges came up in the Texas case.
But Counselor, that has nothing to do with the underlying idea of racial animus. And as my co-justice asked, isn't the obvious statements made by the president, isn't that evidence of a racial animus to a specific group?
Your Honor, they're not, as mentioned in the Arce case, they are not direct statements made to DACA.
Do they have to be?
They don't have to be.
Your Honor, the statements themselves were not targeted at recipients of DACA. They were general statements about immigration issues. President Trump has spoken directly on DACA recipients as good people, good, motivated, and educated people that we should have in this country. He has not spoken directly on that issue. The statements.
In terms of necessity, though, when it comes to looking at examples of racial animus, does he have to? Does it have to be as clear as saying, I hate DACA kids? Or can it be a look at the group itself? Are there any other cases that address this besides the one that you mentioned?
Your Honor, if I may briefly answer your question and conclude, I see my time is running out.
Yes.
Your Honor, in Washington v. Trump, the rulings were following an executive order signed directly by President Trump. In that situation, President Trump spoke directly towards the Muslim ban. However, in this situation, President Trump did not have any direct input in the signing of the order. Therefore, it's our contention that President Trump's actions never spoke directly to DACA, and unlike we would find in the Muslim ban case. Now, if I may conclude, for all the reasons stated, this court should reverse the lower court's decision. The respondent did not establish sufficient circumstantial or direct evidence that the government's actions were motivated by a discriminatory purpose. Thank you.
Respondents?
Madam Chief Justice and Your Honors, may it please the court. My name is Narmada Sapkota, and along with my co-counsel, Sharon Topol, I represent Zoana Diaz, the respondent in this case. This argument is not only about Joanna. What we decide today will have a direct effect on those 700,000 DACA recipients and indirect effect on a million others who are part of their lives. This court should affirm the judgment of the lower court because it correctly decided that the executive power in the enforcement of our nation's immigration law must be exercised in a manner that is consistent with the law.
How is it inconsistent with the law, though?
I'm sorry, Your Honor.
Why isn't this consistent with the law? What has it done that is inconsistent with the law?
That is one of my main points, Your Honor, and that is that it did not follow the proper Administrative Procedure Act when rescinding the DACA program, and that is not consistent with the law.
What would they have to have done to gotten it right?
They would have certainly, if possible, do the notice and comment as rulemaking requires. If not, at least give a reasonable reasoning for their action, Your Honor.
But if the statute or if the act was illegal, if DACA was illegal in the first place, isn't that a reasonable basis?
Not entirely, Your Honor, because even if, and that is not what I am saying, but even if the DACA was illegal to begin with, now it is not just a program. There are 700,000 people on this program and million others who are affected by this program. And also it has tremendous economic impact in our economy, Your Honor. So for those reasons, there has to be at least a reasonable explanation for rescinding this program. It is not that the Secretary did not have authority, Secretary does, but has to explain.
Would the administration have to have a reasonable explanation? Would they have to really worry about the economic impact and the number of people it would affect if it were illegal in the first place?
I believe yes, Your Honor. Because first of all, DACA was not illegal to begin with, but just in case if it was, now the responsibility on the Secretary, Secretary has is the people who depend on it and the economy, and that is very important thing.
I respect the economy and I respect the number of people, but I think the fundamental issue that we're looking at for your argument is, was the underlying law illegal? Yes or no? One word.
Underlying law, for Your Honor?
Yes.
Would you, for rescinding the DACA?
Was it illegal or not? The premise here, the issue on cert, was whether or not the APA even needed to be followed if in fact the underlying legislation was illegal, correct? Am I misunderstanding the issue on cert?
No, you're correct, Your Honor.
Okay, then convince me. Then convince me why you want to say, well, even if it is APA, I want to go back to the basic issue. Absolutely,
Your Honor. And I have, so the way I will get there is by analyzing Attorney General Sessions' memorandum, the Secretary Duke's act of rescinding DACA without giving an explanation. And when given a chance to Secretary Nielsen by the court to explain, the response was just post hoc rationalization. So I will go one by one, and then I hope I'll be able to clear the questions. So in this process, I will address the first arbitrary and capricious issue, and my co-counsel will address that the rescission was in violation of the Equal Protection Clause. Under Administrative Procedure Act, the agency's decision must be upheld unless it is arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law. Under this standard, the scope of review is very narrow. It requires only that the agency examine the relevant data and articulate a satisfactory explanation for its decision, including a rational connection between the facts found and the choice made. In this argument, as I mentioned earlier, I will show that there is no satisfactory explanation or a rational connected between the facts found and the choice made. Therefore, the decision—
Wait a second. Don't we have an opinion from the Attorney General of the United States saying that DACA was illegal? Isn't it rational to base a decision on a memo from the Attorney General of the United States?
Yes, Your Honor. That is a good evidence for Secretary Duke to evaluate, but it is Secretary Duke's discretion to rescind DACA, not Attorney General Sessions' discretion. So in exercising her discretion and to defend her act of rescinding DACA, Secretary Duke has to explain why Sessions' memorandum is correct. It has to come from her own word. She cannot—
Okay, so if that's the case, can Secretary Duke now issue a memorandum saying, for the record, I agree with absolutely everything in the Sessions memo, and I, the secretary myself, deem that it was arbitrary and capricious in the first place, does that fix it?
That would be a post hoc rationalization, Your Honor. Basically, rationalizing her act, she can, if she elaborates more on that, that might work, Your Honor. But just saying that, yes, I agree, would be just a conclusory statement, whatever the.
All right, fine. Then say, I believe that this is arbitrary and capricious. And then writing out a memo, most of which contains essentially the same things that were listed in the Sessions memo. Is that then enough? Because at that point, the secretary has given reasoning, which you say is the reason that this doesn't stand.
In that case, if Secretary Duke gives enough explanation and why this DACA is not, still her explanation cannot be based on the premises that the DACA was illegal, Your Honor. So if she rescinds that and sets a clear, completely new reasoning, then that might work. But since the DACA is not illegal to begin with, and I can explain why.
Let's go with that. Explain to me why.
Absolutely. Thank you, Your Honor. So in DACA memorandum, it sets out that in the first paragraph that it is a guidance document, and it is only to be used for deferral action while exercising a prosecutorial discretion. And Your Honor, the DACA memo clearly goes on saying what is the program, what it does, how it aligns with the Immigration Nationality Act, and how do we use this document. So it does clearly gives a logical reasoning behind the inaction of the DACA program. Your Honor, for that reason, it is not illegal. And there is a statutory authority that guides this program, and I can draw that statutory authority in 3 steps. First, that the DACA, the DSS, the Department of Homeland Security, has the vested authority to make decisions regarding the immigration laws. Second, Immigration Nationality Act does provide deferral action on case-by-case basis in different scenarios. And there is.
I'm sorry, I'm going to interrupt you. I get where you're going. How, in light of all this, how do you respond to petitioner's argument that that Congress has chosen not to enact the DREAM Act, has chosen not to pursue what DACA presumably started, and therefore, that's enough?
I would love to address that question, Your Honor. So, though the DREAM Act and the DACA both focuses on childhood arrival, they are 2 very different programs with different outcomes. Unlike the DREAM Act, DACA does not provide a pathway to citizenship for the recipients. And most importantly, under Chevron Step 1, the question is whether the Congress has directly spoken to the precise question at issue, not the question in addressing the topic in general around the periphery of the issue we have. And the issue we have is a DACA is not looking for a citizenship or any legal status or any way to a citizenship. It is just deferring their deportation. So in that sense, Your Honor, it doesn't satisfy the Chevron Step 1 that, sorry, Your Honor. So yes, and also, for that reason, the fact that the Congress has declined to enforce the DREAM Act or hasn't gotten around to authorize DACA yet does not render DACA illegal. If I may, I'll quickly conclude. Thank you, Your Honor.
Thank you.
My time's up.
May I proceed?
May it please the court. Madam Chief Justice, Your Honor, as my co-counsel said, my name is Sharon Thopel. The second issue is whether the rescission violates the Equal Protection Clause, and in my time before the court, I will show that it does by first demonstrating the disparate impact on Latinos and individuals of Mexican heritage. Second, how the various statements of President Trump has fueled racial animus against Latino and Mexican nationals. And third, the unusual history behind the rescission, which indicates that the typical careful procedures were not followed in rescinding DACA.
I want to interrupt you. I have a question. You said whether it's fueled racial animus. Is that really the standard to show intent? Because the result of it may be one thing, but his intent at the time is another. That's the first part of my question. The second part is, why can't we construe his statements like you would a salesman at a car lot, and it's puffing? Is it really evidence of intent when he's running for a political office? Can you attribute that intent to an executive action? And what is the effect of that if we hold every presidential candidate to their words during a campaign?
Your Honor, determining whether discrimination is a motivating factor demands a sensitive inquiry into such circumstantial evidence of intent as may be available according to Arlington Heights. And there not need be a discriminatory purpose, but just merely circumstantial evidence, as we have here by President Trump's statements, not only during his campaign rhetoric, but also while he was in office. He characterized Mexican and Latino nationals as druggies, rapists, and people who traffic and bring in MS-13 into the country.
But didn't he also characterize DACA recipients in a very favorable light? Do we have to consider that as well?
Your Honor, this was August 2017, I believe, and it was after DACA had been rescinded. It was after DACA rescinded, President Trump made that tweet. So it seemed it was his just quick trying to brush everything under the carpet. The rescission had a disproportionate impact on Latino and Mexican nationals. And the 93%, yes, it is not dispositive. I concede that. Nonetheless, at what percentage do we assign before we find a discriminatory purpose?
And yet, Counselor, at what point do we have to ignore the basic fact of how immigration trends had been working in the United States? The majority of immigrants these days do seem to come from Mexico, from Hispanic areas, whereas in the 20s it was very Asian populated. So at what point do we look at those types of disparate impacts versus just the waves of immigration?
Your Honor, that the immigration patterns, yes, as our petitioners would like us to believe, is what is the issue here and not the discriminatory agenda of the current administration. Nonetheless, the fact that these DACA recipients are not treated like other immigrants, they're held to a much higher standard. They are required to have clean criminal histories. They're required to become productive members of our society, just as Johanna Diaz, on whose behalf we are before the court, who grew up homeless as a child and earned her way through college, graduated from law school to serve the underserved members of our nation in immigration and criminal proceedings. The Department of Homeland Security has yet to articulate what policy has fueled their rescission to facilitate the deportation of nearly 700,000 men and women who came to this country through no fault of their own. And their parents, yes, were undocumented immigrants. And yes, President Trump's statements were not directed to DACA recipients. Nonetheless, coloring the DACA recipients' parents and those who are associated with them under such a negative light has fueled racial animus against Mexican Latino nationals. Yes, Your Honor.
Thank you. And I want to say your last name right. Is it Thopiel or Topiel?
Thopel.
Thopel, thank you. Ms. Thopel. My question is, when you really look at this in the big picture, I mean, it's called the deferred action. Deferred is in the title. Isn't it just understood that there is a temporary nature to this program that, that allows, the administration to change it or change their minds, or it's deferred. It's not there could be another word. So how is it discriminatory to decide not to defer anymore something that had been allowed to be deferred?
Your Honor, I find it troubling because deferred action, yes, it was to be renewed every 2 years, but we have several thousands, hundreds of thousands people who relied on this program. And yes, that is not enough. However, we also look to the fact that the DACA program, they also were discriminated against through the racial and derogatory statements made by President Trump.
I have a question about those statements.
Yes.
The petitioner seemed to say that unless the secretary herself made the disparaging statements, they don't count. Do you have a response to that?
I would say that because the secretary and acting secretaries are presidential appointees, that they carry out the administration's agenda and whose head is President Trump, Your Honor. Your Honor, Countess, Judge Count, did I answer your question?
Yes, thank you.
Thank you. It is hard to believe that President Trump had no influence on the decision makers, as petitioners would like us to believe, because of his statements. And furthermore, circumstantial evidence is the standard, as according to Arlington Heights, which may be considered in evaluating whether the government action was motivated by discriminatory purpose. Even though President Trump has at other times shown support for DACA recipients, this is simply not enough. Furthermore, the unusual rescission came only 3 months after the program had been affirmed by the agency. And imagine being one of the DACA recipients who had the program's affirmation on their mind and they had the security in their hearts. Afterwards,
Was it by the same administration, or was that a different administration?
same administration.
Thank you.
So it's merely 3 months afterwards to have the program snatched away from them. They're having the only home that they've ever known snatched away from them in that same.
Well, I'm sorry, I'm going to interrupt just because I know that time goes really quickly.
Yes.
What is your best case? What is your best equal protection case that's analogous for why this was a violation of equal protection?
I would bring in this case of Arizona Dream Act Coalition, where the court reasoned that because dreamers were likely to suffer irreparable harm unless the defendant's policy was rescinded, and the balance of equities and public interest, that there was an injunction that was placed on the state's claimed interest that they would not allow undocumented immigrants to show their work status and their work papers to obtain their driver's license. And in that, likewise, there are thousands of DACA recipients here whose fate lies in the balance would suffer irreparable harm if DACA is rescinded as the petitioner's desire, including Johanna Diaz, whose parents brought her here, yes, as undocumented immigrants, but has worked to serve our country. And furthermore, along with that case of Arizona Dream Act Coalition, the court held that the injunctive relief should have been granted for undocumented immigrants, since the state of Arizona's interest was not rationally related to treat DACA recipients disparately from recipients that were citizens of the state. Likewise, what federal interest has the Department of Homeland Security shown us to invoke the right to deport nearly 700,000 who came to this country through no fault of their own. In closing, although the executive wields awesome power to enforce our nation's immigration laws, it must exercise its power in a manner that is consistent with the law. And as Justice Breyer stated in his dissent, that it does not permit them to make purely policy choices for purely political reasons, nor to rest them primarily upon unexplained policy preferences. So considering the disparate impact, President Trump's statements, and also the hurried and brash manner in which DACA was set aside, we ask the court to affirm the decision of the lower court and to continue to uphold justice and protect DACA recipients from the unfair, haphazard rescission which the government would seek to advance. Thank you.
Thank you. Now there are 2 minutes that have been allotted for rebuttal.
Yes, Your Honor. To the first point, respondents contend that the department did not follow the Administrative Procedure Act when rescinding the program. Specifically, respondents contend that the department did not provide a sufficient justification for its decision. But as this court stated in the Department of Commerce v. New York, under the narrow and deferential arbitrary and capricious review, the court must determine only whether the department examined the relevant data and provided a satisfactory justification for the decision. The secretaries here examined the relevant data. They reviewed the administrative history behind DACA, including its creation, but also examined DAPA and the related Texas litigation and Attorney General Jeff Sessions' memorandum on the legality of DACA. And under Title 8, Section 1103, the Attorney General's opinion on all questions of law is controlling. So with that said, the department provided a satisfactory justification for the rescission, stating that in accordance with the Attorney General's memorandum on the law, the program should be terminated.
Conflicted with a prior AG opinion. If it's controlling, what if it conflicted with an AG opinion that had been previously issued? What would the effect be?
Your Honor, I don't know the specific answer to that question of two attorney generals giving inconsistent opinions, but my impression though is that the current attorney general's opinion would be controlling under the statute. And so with the attorney general's controlling opinion, the department stated that the rescission should be.
I'm just going to pause here just because there's one thing I wanted you to address. Can you please address the second respondent argument regarding the unusual rescission that the administration upheld DACA and then 3 months later rescinded it? How is that not an equal protection issue?
Your Honor, because for an equal protection violation to arise, there must be a disparate impact, but also evidence of discriminatory intent. And yes, the president has certainly made inflammatory and offensive comments regarding immigration generally and crimes that are unfortunately committed by undocumented immigrants. But respondents have not pointed to a single piece of evidence of discriminatory intent on part of the department's secretaries. And they are the true decision makers here. Because remember, the DACA was rescinded by the secretaries, not by the president through the president's executive order.
Okay, thank you. Thank you very much.
Mm-hmm. And further,
Looks like your time
is concluded.
Sorry, Your Honor. Oh, yes, Your Honor.
All right, thank you very much to all participants. Excellent argument. I'm going to ask the Blakely Butler folks to step in to let us know what we will now do in terms of deliberation.
Awesome. So how we've done it, the rest of the competition is usually we put the judges into a separate breakout room. If you guys would like to deliberate amongst each other. And then what we'll do is if you can please then send me the scorecards to my email, then we can tally it up and we will let the competitors know. I guess the idea was that we would let the competitors know here and now who won after you have the chance to deliberate. So I believe Judge Weems is the host, or do you have control, Chelsea?
Certainly, I will put all 5 of the judges in a separate breakout room. Just give me 1 moment.
Awesome, thank you.
We're in timeout.
The room has been created. Please join.
Congratulations to all of our competitors. So whenever they come back from their deliberations and they send Paul the score sheets, Paul will be tallying up that, and then the judges will be able to give you some feedback. But congratulations, everyone. I know that was a tough round. That we had 5 very smart judges, 5 judges who were listening very closely and who came with lots of great questions. I think that everyone really handled that really well. So congratulations and hats off to you.
Chelsea, I wanted to throw up.
No, y'all did great. Y'all really did.
Oh, we're still live.
I was
YouTube
wondering
see
if
me-
you were
see me
still
say that?
live.
Yeah, wait, everyone on YouTube. Right now we have 26 people watching live.
A lot of people.
Really exciting.
Everyone, whoever is watching, thank you so much.
Yeah, I also wanted to say that I thought you guys did great. This problem was difficult, and I think that the judges also asked you a lot of difficult questions and stepped in and interrupted you a lot more than I had seen in the previous round. So you had to think on your feet and sort of react to what they were doing, and I think all of you did a pretty good job. So I guess we just wait to see who we announce the winners, but even second place, y'all did great. So you have only things to be proud of.
And I am monitoring the YouTube right now. So, if anyone wants to give some words of support from YouTube, we have one from John, who said, "This was an excellent debate. Thanks to our esteemed judges, professors, and competitors. Y'all rock." We have another one saying, "Great work, guys. I enjoyed it." These are just some words of encouragement from everyone else who's watching, because again, this was tough run. Someone said that was brutal, but you killed it. So lots of encouragement. I think that we're all in agreement that we were all like, man, I don't know how I would have survived some of those questions. So you guys feel really proud of yourselves. You really should.
It would be an honor to lose to you all, so thank you.
Yeah, being a petitioner in this case wasn't easy.
Yeah, it's like we have all the bad facts.
So whenever we did a very similar problem for the Hispanic National Bar Association competition last year, that's what I based this problem off of. And then our coaches would also always say that the government had the stronger legal arguments if you looked into the case law as to why it was not arbitrary capricious, but definitely the side of Joanna Diaz has a stronger moral ground, so to say. Like, you can sympathize a lot more with that ground. Plus, then you throw in President Trump's comments, and you throw in a lot of other things, and there's a lot of I guess, I don't know, chances for you to make difficult questions and for the judges to decide one way or the other.
And we got a few more comments from the live stream. Chase said, "Feeling better about losing to both of these teams." We have another comment saying, "Way to go, both teams. Y'all did amazing. Heart, Team 11." We have another comment saying, "Yes, super glad it wasn't me." And another person saying, "Same here, Chase," referring to Chase saying, "Feeling better about losing to both of these teams."
So I'm starting to receive the score sheets. I will turn my video off to start doing the scoring, and I'll be back once the judges are ready.
Yes, and it feels like it's a fierce deliberation happening, because it has been at least 4 minutes since they went to the other break room and we started reading comments. But again, it was a tight match. Everyone did really well. So again, that's a huge feather in y'all's cap, especially to be doing this over Zoom and adjusting to this platform, I think is really fantastic.
And I am just grateful that my toddler is sleeping and not kind of not just trying to get my attention standing outside the door.
Yeah, these past 2 days, my dog barked, I think 2 or 3 times in the middle of a round. So she was right next to me.
Yeah, way of trying to get your attention, I guess.
Yeah. Or saying like, "Hey, stop asking all those tough questions. Like, leave them alone." And we have another comment from Miguel saying, "Good job, guys and gals."
Thank you.
And another one, "She did well. Great job sleeping." Oh, I think that was in reference to your daughter.
I don't think I was breathing for like the last however long. It was great. That was amazing. That was fun. That was a lot of fun.
But like I said, y'all handled it really well. I'm sorry that my cards are a little bit on the light side. We got another comment saying RBG would be proud.
Oh.
And then, yeah, another comment saying, yes, you did right by RBG with 3 exclamation points.
You have to be like such a cool person to just be known by your initials. That's just,
Yeah.
that's incredible.
Okay, another comment. Fun facts. Ted Olson held 3 focus groups with the DACA recipients to make sure he didn't say anything offensive when representing them. That is a fun fact. Yeah, as a matter of fact, some of my RPG stickers stuff right here. These are actually little tattoos that I got.
So cool.
Yeah, I got these a couple of years ago. Whenever I got my Ruth Bader Ginsburg little doll, it came with all these cool things. And yeah, and I of course never used it because you know, single use.
Mhm.
Appropriate. Okay, we have another comment from Maria Sanchez saying, great job, guys. Yeah, and we still have 24 people on the live stream.
Oh my goodness.
I know, I feel like we're famous.
No, I just feel like, oh my, who are these people who are so committed? Thank God. Thank God.
Well, I mean, this is a great experience for people to be able to watch and to witness, you know, two teams who have been through multiple rounds, who've made it all the way with these great arguments, kind of seeing how it works, I think is really fantastic for people to be able to benefit from, you know, seeing you guys in action. So yes, definitely appreciated, you know, that we're able to do this, that, you know, I got to give credit to Judge Weems for setting this up and for also inspiring the idea.
Honestly, I was just hoping that the judges would let me finish my introduction and, you know, get into my argument before they start asking questions. But my, you know, worst fear came true. It's really it's a quite an experience.
But the good news is when you have really tough rounds like this, it makes rounds where the judges aren't as tough. You know, it makes them so you can really appreciate, you know, the being able to get through without on the spot being asked a really difficult question, which was, you know, a lot of the situation here tonight, which again,
Yeah.
you handled really well.
Yeah, and also like it's fun and it's good to, you know, answer those questions really, because that's what we have been, you know, preparing the whole time, right? And it feels good to actually, you know, answer those questions. Oh yeah, I know, you know exactly what to say at that time. So it was good.
Knowing exactly what to say is not something I felt at all.
Not exactly what to say. Well, in my opinion, right? That's what I thought was the right answer. It could be, you know, way off the league. What I thought.
Okay, the judges are done deliberating. Please return to the main meeting. Okay, great. Also, a few more comments. Everyone's saying great job. From one of the other competitors that I really needed closure after the last 4 days, I guess in response to your comment that the people who are still on the live stream are very committed. And then someone else said same, Zach. So I guess, you know, a lot of people are your fellow competitors who you've gone against, cheering you on, and, you know, really excited to see the results, which is wonderful, because again, normally we get to do this type of thing in Crest Hall where everyone can come see and kind of be a part and participate, you know, that way as an audience member. And so it's really fantastic that there's a way that we can kind of replicate that a little bit. It's still it's got that Zoom flavor, but people can join in and watch. Yes, and another comment saying, great job, well done. So I believe the judges will be coming back soon. Let me see who are the non-video participants. Judge Weems and Paul. Okay. Here they come.
Hello, I am still missing a couple of score sheets. I was hoping you guys could please send them to me before we announce the winners if possible.
I just sent mine.
I sent mine
Okay.
too.
Okay, I should be receiving it shortly then. Excuse me.
Okay, perfect. And while you are tallying those up, let's have some feedback from the judges for our competitors.
Oh, and actually, before we do, is this part on YouTube?
Yes.
Okay, so the feedback is also on YouTube.
That's a
Okay.
good question.
Oh, yes, we're still live streaming and we still have a crowd of 24 on the stream with us. So, yes.
Who wants to go first?
I think the moot court coach should go first.
Sorry, I'm also the one who's having technical difficulties. I'm trying to resend my ballot.
Oh, go ahead.
I haven't gotten it, so if somebody else could go while I have to take a picture of it. It's so sad.
Let's start with
Mine-
the Court of Appeals justices and work our way down.
I was just gonna say, mine will be pretty quick. And it's global feedback. It's not for one in particular person. And keep in mind, I can say this because I've practiced for a long time. I'm on the bench and the feedback we give you may not be something I don't know, that you would have even been able to do yet. I don't remember, right? Honestly, like I don't know how good you can get as a law student. All of you did a great job. I think that you need to give yourself some credit for the fact that you did this virtually, because there is a whole lot to be said, even with appellate stuff where there's not that many people in the courtroom, for feeling the energy of other people, closer to you, that can really help keep you focused and help keep you sort of in it. So
Justice Countess, can you please introduce yourself to them? They may not know who you are.
Oh, I'm sorry. I thought we did that earlier. Yeah, I'm on the First Court of Appeals. So yeah, Julie Countess, nice to meet you. So what I would say is this, you don't have a lot of time. You know that. I know you're coming in and you're like, I don't know what they're going to want to know the most about. You kind of do. So be ready to skip the intros and the long, the script. And especially if you're going second and you've picked up on some themes or some issues or some concerns, it's obviously, it shows how smart you are that you know the case law, but at the same time, in real life, we're gonna read those cases. It's not a test. And so sometimes it's just to jump right in and be like, here's why this doesn't make sense. It doesn't make sense because blah, blah, blah. Anyway, just don't be afraid to jump out of your script. And that's going to require you to be super, super, super familiar with your argument and all that. And I have no idea how much time y'all had, to get ready, but it's no judge is going to be like, well, this doesn't sound formal enough. You're not answering me like we're in a law school exam. No, we only have a small amount of time and we want to get right to it. So don't be afraid to do that. That's it.
My name is Sarah Beth Landau. I'm a colleague of Justice Countess's on the First Court of Appeals, and I agree with everything she said. I made a few notes as we were going. I don't know if it's helpful for me to just kind of go through everybody and give a little bit of feedback for each, but that's kind of my plan. First of all, I thought you all did a great job. The Zoom format is very challenging, even for very experienced practitioners. It's hard to kind of keep your energy up and be conversational when you're not in the same space as the judges. So I thought you guys did a good job with that. Beginning with Mr. Guerrero, I thought you were very polished. I thought that sometimes that strayed a tiny bit into me feeling like you were reading a little bit. I know it's just really hard on Zoom, but as conversational as you can be, that's always a good way to connect with your judges. I thought you had great use of authority and you had good factual knowledge, and you kind of dropped some fact bombs in there where appropriate. One thing, when you use authority or a judge asks you for your best authority, it's great to say the case and have that on the tip of your tongue, which you did. It's even better if you can take it one step further and say what the parts of the test are and how they would apply here just as quick as you can. I know your time is limited and you have to triage, but that Chevron case is so important. I probably would have dealt with it in a tiny bit more detail if I had the time. Mr. Sanchez, I also thought that your use of authority was good. I liked your what we used to call in federal practice, the 28J letter. I don't know exactly what the answer is, but I will get back to you. That's exactly how a professional would handle it. And I thought you did that really well. You know, it's hard to connect over Zoom, but I thought you all did a good job of that. Ms. Sapkota, I thought that you had good demeanor. You also talk a little fast. So I wanted to hear what you had to say. And it was also hard to get in to ask you a question because you talk so quickly. I wanted you to take a breath so I could jump in and ask you something. One thing I noticed, if a judge asks you yes or no, even if they're being very unreasonable, the first word out of your mouth has to be yes or no, and then you can go back and explain. So I could have also used a tiny bit more signposting in your argument to kind of know where you were headed. Ms. Topol, I thought you had some really good factual knowledge. I liked the use of the timing of the president's tweet. It was very, very specific, and it helped kind of orient me, at least as I was listening to you. I thought your pace and your demeanor were also very good. You were very easy to follow. And yeah, I thought you had good factual and legal knowledge, both. Thank you all. I thought you did a great job.
I agree with both of the things that they said, which not surprising at all. And then I have a couple of things just that may be helpful. Mr. Guerrero, I agree. I thought you were smooth. The thing I liked about it is you didn't get thrown by a question. I think this is important for every advocate. You shouldn't be nervous about questions. A question in an oral argument is an opportunity to convince a judge. So the best thing about an argument is when you get a question. So I thought you handled it well because you invited a question and it didn't seem to throw you off your game. I agree that when you transition back to your argument, you wanted to read a little bit more rather than kind of wrap it up. But I think you had a great demeanor. Mr. Sanchez, I think you knew the law and the facts well. I think the thing I would encourage you to work on, and Ms. Sapkota, is to invite questions, that you weren't as anxious to get a question as I would like for you to have been. And I know it's nerve-wracking, and I can say this from practicing 30 years, it never goes away. So you're always going to be nervous before you stand up to argue. So I would just encourage you to work on that. Ms. Thopel, I thought you did a nice job and had a good demeanor. And the thing I especially liked is you're married to the policy argument, and you use the facts really, really persuasively with regard to making your policy argument. And I thought that was a nice job. And I agree. I'm going to add on to something Justice Landau said to Ms. Sapkota and to everybody. When you get a yes or no question, answer yes or no. And if it's an answer you don't want to give, you answer it and explain why it doesn't matter. Yes, but that's not legally material, and this is why. You pivot to why your bad answer does not harm your argument legally. And I'm going to jump back to you, Mr. Guerrero. I did want to point out, when I taught appellate advocacy, I always told the students that you should have what I call base. When I was a kid and played tag, you need to find a place that's safe where you have an unassailable argument. I thought with regard to your first premise, you didn't have a base if we would not accept your argument that not acting was the same as affirmative action. And you need to find your sort of second tier response. Like, if I reject your premise, where do you go with it? You have to have that in the tank. But I thought y'all all collectively did a great job. Good job.
Thank you. Thank you so much for your feedback.
Okay, I guess I'll quickly go. I'm Cassandra Jew. I'm a moot court coach at UHLC. Just really quickly, if you don't mind my asking, are any of you on the moot court team by any chance? and you might all want to consider it. I will just give a little general comments. I agree with everything that the justices have stated so far. I will say always watch your time. That's very important, both in practice and in moot court. Courts, it's really up to their discretion whether to extend. Most often it'll be no. The base is absolutely very important. Also recognize who you're arguing to. You were arguing to the Supreme Court, and for the most part, in moot court, we can always do what we want. So in moot court land, I would say policy arguments and a base, very important. Actual case law in a moot court argument, not real practice, not necessarily as important. I will say that definitely answer a question, and this is for everybody, and in practice, this is actually global. When you are the respondent, you have a unique opportunity. These are conversations with the court, and during the petitioner argument, you get an idea of what the justices are really looking at, the things that bother us. And so if you can come in swinging with those things and say, I noticed that that Justice Landau, that you were concerned about X. Let me expound on that. That would be extremely helpful, because it helps. It just like if we had a little question in our mind and you answer it, it can really push us to the next place. Also with this, and the same goes with rebuttal. If there's something that the respondents were really pounding on, that we weren't buying, that we were having trouble with, this is the place to go with it. So think of these as conversations. You start with your points, but really do try to invite questions and invite issues. You know this, and honestly, you probably knew this better than we did. So just don't be afraid of it. Just launch into your arguments. But great job, everybody.
Thank you.
So I've got more specific comments to each of you, but I'll just say generally, I thought y'all did a great job with what is a very difficult, complex topic. Mr. Guerrero, I really liked your signposting. I thought you did a nice job. I think you have a very calm delivery that I personally find very persuasive. So that's my feedback on you. Mr. Sanchez, I felt like your delivery got a little choppy at times. I think you might have gotten thrown off by the questions. I also just kind of felt like maybe you didn't really believe in the argument you were making. And what I would say is you are very unemotional about it. And I think I'd like to see just a little bit more emotion. Don't get me wrong. Moot court is not where you're going to make these grandiose gestures and the kind of things we do in the trial court. But I would have liked to see just a little bit more emotion from you. Ms. Sapkota, you're very smooth. Let's see. Yeah, find you on my screen here. There we go. Okay, you're very smooth. You did get flustered on the questions a couple of times. I think the advice that Judge Moore gave is great, which is questions you got to get excited by them. All right, now I've got these folks engaged, and I think you were kind of a little bit more defensive than you should have been with the questions. Ms. Thopel, you are very, very calm. You've got a great delivery. Like Mr. Guerrero, I just really like the way that you deliver. You've got an excellent presence. One thing you said, I find this very troubling. Frankly, the court doesn't care what you think. Your opinion is irrelevant here. What's important is what the law says, and maybe even some public policy arguments. But just one thing to keep in mind is sort of a term of speech that I would avoid if I was arguing to the Court of Appeals. That's all I got.
Thank you, Your Honor.
Thank you.
Thank y'all. Thank you for spending your Sunday night doing this, or Sunday evening doing this.
Thank you.
You're welcome.
So unless there's another comment by any one of the judges, we'll now announce the winners. Okay, well then I wanted to say congratulations to both teams for making it this far. The competition has been brutal up until now, but special congratulations to Ms. Thopel and Ms. Sapkota for being the winners of Blakely Butler. So thank you for that. And Ms. Thopil, you have won the Best Speaker Award for the finals, for the final round. So congratulations for you both. I know that both teams will receive prizes, and we will, I guess I will email you directly about that later. But from me, I want to say special thank you to all the judges who participated. I've heard nothing but good things from the students. They especially have found your feedback very useful, and really from the bottom of our hearts, thank you for spending your time to do this for us and to allow us to have this competition in the middle of COVID and everything. So, well, that's all I got. And just a big round of applause to the competitors and to the judges for doing this.
Glad to do it.
Thank y'all so much. Thank you. I'm like crying. Thank you.
Let me see. This is how we can do the applause.
All right, thanks, y'all.
So just a quick note for the students, just so you know, it's been live streaming this whole time. I'm about to turn it off, but I highly encourage the participants to go back and watch it. You can watch it using the same YouTube link because I think it's really important for you. You don't realize it when you're in the thick of it, and you think that you do know what you look like over Zoom. Well, but I think it's very telling if you just take a moment to look at some of your arguments and kind of how you appear, how you look, what it looks like you're doing. I think that kind of alleviates a little bit of it looks like some of y'all are reading, because if you actually look at yourself while you're doing it, it looks like I'm not saying you, but just in general, we did a Zoom mock trial tournament last week, and that was a problem that came up a lot. So just thank y'all so much. If there's nothing further, Chelsea, then I'm going to stop the feed.
Goodbye, everyone.
Good work.
Thank you.
again. And congratulations.
Thank you.
Yeah, congratulations.
Thank you. Oh my God. Okay. Thank God.
Congratulations, y'all.